Nnamdi Kanu blasts Justice Binta Nyako. In court, you stand recused. You are very biased, and it's shameful to insist on hearing my case. Nnamdi Kanu, the detained leader of the indigenous people of Biafra, IPOB, on Monday unleashed a bombshell defense against Justice Binta Nyako of the Federal High Court, Abuja, the Nigeria's prosecution and the chief judge of the High, for insisting Justice Nyako must try him despite having been recused herself. By a court order from the case, Kanu, who went on rage during his court appearance, blasted Justice Nyako for insisting on presiding over his case, saying she is very biased, hobnobbing with lawyers and justices, and that it is shameful to insist on trying him against the order of the court. The IPOB leader added that the prosecution counsel is behaving like a child because of 300 million naira he is being paid from the Office of the Attorney General of the Federation and Minister of Justice, AGF. The enraged IPOB leader said, "I have a court order. You have recused yourself. Anybody who disagrees with this order of court should go to appeal court. That is what you tell me all the time. You have been recused. You cannot preside over this case number again. Not in this life, not now, not tomorrow. Not ever, you cannot." He added that the prosecution could not force the court to preside over his case. Not today, not till forever. You are recused and you stand recused. He continued. "Tell the chief judge," Nnamdi Kanu said, "go on appeal. I recused you from my case. The state recused Justice Adama from my case, and they did not insist that Justice Adama must hear my case. Why must you insist to hear my case? I don't want you to hear my case. I don't need you in my case. You are biased. You cannot be in my case. You cannot be hobnobbing with lawyers, hobnobbing with justices, and you are preceding a case. It is shameful, absolutely shameful. This is not a court of law. This is a shrine to injustice, and I will not subject myself to it. You stand recused and you must leave my case. You cannot try me. There is an order of recusal, and she is a senior advocate, for goodness sake. Is that not the rule of law? The law says if you disagree with this, you go on appeal." Also blasting the prosecution, Kanu said, "You are a grown-up man. Because of 300 million naira, you are behaving like a child. Go on appeal. Because of money they are paying you from the AGF's office, you are here standing and holding evil. A grown-up like you. Behave like a man of honor. The rule of law says you should go on appeal. His Lordship Justice Binta Nyako can't try my case, not on this planet Earth. I'm telling you that now, so stop wasting your time." He added, "An order of the court says Justice Binta Nyako is recused. The same Chief Justice writing the stupid memo he is writing, I recused him. He was a functus officio. He sat on appeal. I took him to NJC and I recused him. Why did he not say he must preside over my case? Why in the case of his lordship is he insisting? He wants to embarrass her by asking her to come and sit on this case. When the prosecution told him it was not right to insult a judge, he said, 'If you insult yourself, I will insult you. If you have no respect for yourself, we'll insult you because you people are turning the law.' When it comes to Nnamdi Kanu, you turn the law upside down. The law says this paper is white, but you people say it is black, and when the law says it is black, you say it white. Is that law? As the senior advocate of Nigeria, is that law? Is a memo from the chief judge sufficient to set aside the court order? Why do you want to change the law in my case? His Lordship Justice Binta Nyako stands recused in my case and cannot try me. People without shame. National Judicial Policy of Nigeria. Talking about a memo from the chief judge of a high court. National Judicial Policy of Nigeria IC says, in the performance of judicial functions, the judge is subject only to the law and must only consider the law. A judge must take or attempt to take orders or instructions of any kind from anyone, including chief judge, that may influence his decisions in the performance of his judicial functions. The rule of law in every common law jurisdiction in the world is that once an order of court is entered, the only way to set it aside is by going on appeal. You are a senior advocate and you don't know it.